There we go. Getting better at this. At least I think I am. Bitch. Did I ever sort of, yeah, I don't know. I don't know how to play it when I'm on the screen.
He shot you, not Mr. Barrisone. That's the same situation.
And that you had contact with her on the 20th. There was some physical. Mr. Brooks, this is my time. You need to not interrupt.
The charge was dropped.
Mr. Brooks,
The state
you need to stop.
said specifically, wrote you, Your Honor, and said that they know it was no incident that day.
Mr.
And now
Brooks,
you want to sit up here.
do not interrupt me
you-
or you will be removed to the other
And now you want
courtroom.
to sit up here
Stop.
and try
Now.
to add something in that you know for a fact never even happened. You want to sit up here
Mr.
and talk
Brooks,
about
every
who has
time
grace and all this. You talking about someone with 5 kids that don't have custody.
you need to stop
None of
right
them.
now or you will be removed.
Remove me then.
All right. He will be removed. He cannot simply stay
I don't
quiet when
consent to
this
being
court talks.
sentenced anyway. I don't consent to this. Just like I told you, I don't know the
We'll be in recess until he's
I don't
removed
even
to the other
understand
courtroom.
the true nature and cause.
Dude. At the end of the day, man. I'll figure this shit out eventually, man. Yeah, this dude is the dumbest motherfucker ever. Like, I just wish there was a way that I could, like, pause and play this shit at the same time. Yeah, it's okay, man. I'm gonna delete this shit anyway.
Implicit adoption of what he was saying is improper arguments. Or in the court should just.
Okay, but what you are doing right now is highlighting something and making more of a spectacle. So if your office in general does not want to facilitate and or incite violence, then we need to just sit down and move on. That's it. There were 18 witnesses, 16 or 18 witnesses that testified today. There was nothing that was said until Ms. McNeil made her point made, and, you know, we're moving on.
But is the court going to do anything about maybe stopping it from happening?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and
So what do I have to do it like that, huh? Hmm. All right.
and joking, Ms. McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper.
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door
I
open.
don't understand this.
For me, not for you.
You can do what I'm trying.
My understanding of
You
your,
should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
that was not our motion.
Excuse me. I did. I granted.
We did not move
That
to
was their
reconsider.
motion.
We've not filed any motions to reconsider in this case.
It was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you without any advance notice to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. Yeah, that's absolutely untrue. And there's no. Your arguments of record, my comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest that anything's changed, even if you're correct in your assumption that you know more than I did at the time. You should have come to the court and say, I want to go into this.
It's all good.